Good afternoon. This is Greg Lois, and I am teaching a webinar on avoiding reimbursement pitfalls. So I hope you're here today to learn a little bit about this fun and exciting subject. Okay, this is completely and totally live. If you're attending here today, I'm hoping it's because you want the benefit of attending live, which is you get to ask me questions, and I will do my best to answer your questions about subrogation or reimbursement issues. And we're going to be talking broadly today. I'm going to be talking about New York and New Jersey statutes and comparing and contrasting them, but really trying to arm you with how to do the best you can in your reimbursement activity, whether that's negotiations or making sure that you're securing your maximum reimbursement. I want to give you some information that we've won the hard way through experience and share that with you so you can do a little better with your reimbursement or subrogation actions. Again, this is totally live. Please type in a question if you have it into the GoToWebinar slide. I will do my best to answer your questions to the best of my power. I will say your first name so you know I'm answering your question. I will then read the question so everyone in the audience knows what the question is, and then I'll do my best to provide you with an answer. All right, let's begin. Let's dive right in. Let's start talking about Section 29 and Section 40 basics. And I think it's useful to talk about both of these states at the same time. Section 29 applies in New York, Section 40 applies in New Jersey, and compare and contrast them a little bit. You're going to see there's a lot more similarities than there are differences. And also the general advice that I'm going to provide you about how to avoid the pitfalls, how to avoid the problems and the issues and the obstacles are really going to be very similar in both states as well. So let's begin. Section 29 is the section of the New York Workers' Compensation Law statute that gives us the opportunity for both reimbursement and to bring a subrogated action if the claimant fails to bring their own action against the actual tortfeasor. We have a lien on whatever the third-party recovery is, less the cost of litigation, which is calculated as attorney's fees and costs in securing that settlement. So typically what we're going to see is an attorney's fee in the range of about a third, and then usually on 5 figures and under in terms of attorney costs. And this usually results in a reduction in our reimbursement amount of about 33 to 36% or so. New Jersey has a very similar statute section, Section 40, which gives us the lien on any third-party recovery that the petitioner receives. But New Jersey says our lien can only be reduced by a maximum of 1/3, and that the attorney's fee reduction, or I'm sorry, cost reduction is only $750. So if the attorney in the New Jersey matter goes out and spends $50,000 on experts and site inspections and investigations, the workers' compensation carrier is only required to contribute $750 towards that cost of litigation. So that's one really big difference between these two jurisdictions. Now, the whole goal of these statutes, Section 29 in New York and Section 40 in New Jersey, is to avoid double recovery. And there's a lot of case law we could cite, and you can see some up on your screen now, which stands for the proposition that the idea of these statutes was to prevent unjust enrichment, to prevent the petitioner or the claimant from recovering way in excess of their actual damages and way more than they're entitled to. The idea here is that, yes, we do want the plaintiff who has been harmed by a third-party tortfeasor to go out and recover against whatever entity actually harmed them. But both state statutory schemes envisions that the workers' compensation payer, whether that's a self-insured employer or a carrier, should then be reimbursed from the proceeds of that third-party settlement. And the idea here is, again, to avoid a double recovery to the petitioner. So what do we need to do? What do we need to do to make sure that we get our maximum reimbursement? And that really should be our goal in these cases. Well, the first thing is we need to know exactly how much we've paid for medical benefits, indemnity benefits, and that would include any compensation. So I'm thinking about medical payments, I'm thinking about wage replacement, and then I'm thinking about any permanent residual disability compensation. Typically, We'll ask our client, how much did you pay? And they'll send us a payment ledger. So pretty clear and straightforward. The next thing we need to figure out and get correct is to keep the lien from changing while we're negotiating the settlement or the resolution or the reimbursement. And if it does change, we want to make sure that we're protected. I could tell you that in all of my Section 29 consent letters in New York, I say, hey, this consent is given as of this date, but if my lien is increasing, you have to reimburse me, and I'm going to put that language into all of my consent letters. I'm going to be looking for my opposing party, my opposing counsel, or the plaintiff's attorney to provide us with a proposed closing statement. And I want that, right? I want to know, what do they think their costs are going to be? What do they think their attorney's fees going to be? And what do they think the overall recovery is? That helps us determine how much of a reimbursement demand we actually have and how much of a likelihood of recovery we're going to have. Afterwards, a closing statement is what I'm going to look to. That's going to be filed with the court or served on all parties. Now, in New York, in a civil action, if the civil action's filed, once that's done, you have to file the closing statement with the court, and it has to be filed within 60 days. So you're going to get a very good, clear, and factual accounting of exactly what the plaintiff recovered in that action. Our job is going to be to get to some kind of terms with third-party counsel, right? Often that's negotiating a reimbursement amount. It could be waiving a reimbursement amount. It could be waiving our future exposure. It could be doing a global settlement, in which we're maybe waiving our current reimbursement amount to fund or in consideration for the workers' compensation settlement. So there's a lot of choices there, but we've got to get that right. We've got to get that negotiation right. And then we've got to put together an agreement that memorializes that. And we've got to make sure that agreement is rock solid. When I write a consent agreement, when I write a settlement agreement, when I write an agreement consenting to a settlement in another state or jurisdiction, I always think to myself, what is someone going to be thinking, or what are the issues they're going to face if they have to resolve this 2 or 3 or 5 or 10 years from now? In other words, I want that agreement to be as complete as possible. Now, in fact, our consent letters, you take a look at them, they're like the kitchen sink consent letters. There's a lot of boilerplate in there. There's a lot of information in there. And really, a lot of what we are going to be doing in a consent is going to be governed by statute and case law. But still, we like to cite to it, and we like to put that in there because we don't want there to be any confusion down the road as to why we asserted the rights we asserted and what our expectations for reimbursement really were. All right, so let's talk about some of the obstacles or issues or challenges that we have to be mindful of when we're seeking our maximum reimbursement or considering subrogation of an action. So the first one is, what are the statute of limitations? And there's a lot of statute of limitations that apply in a workers' compensation case. Typically a workers' compensation case, the Workers' Compensation Act, and part of that case is going to involve bodily injury. So the first one we're going to look at is, what are the statute of limitations for the plaintiff, or any plaintiff, to file a personal injury action? Well, in New York, it is 3 years, but in New Jersey, just right across the river, just a mile away, the statute of limitations for a bodily injury claim is 2 years. So that's something to be mindful. But both states, the wrongful death statute of limitations is 2 years. And then they have different statute of limitations for things like different causes of action. So for example, medical malpractice is 30 months in New York, and it is 2 years or 24 months in New Jersey. Legal malpractice is 3 years in New York and 6 years in New Jersey. That's another example where they're very different. Intentional torts have a 1 year statute of limitations in New York, 2 years in New Jersey. They're really just lumped in with regular torts. Loss transfer statute of limitations begins 3 years from the date of each successive payment in a motor vehicle accident case. And then there are abbreviated statute of limitations. For example, shortened statute of limitations for the state, because the state says to themselves, hey, how can we protect ourselves from lawsuits? Let's make a really super short statute of limitations. So all of that stuff has got to be, we have to be mindful of that. And then the last little note is, a civil action against a public entity in New York is possible, again, with that short statute of limitations, and a claim against a public entity is allowed and available in New Jersey under Section 59 of their statutes. but we're not allowed to subrogate on a Title 59 or Section 59 case against a public entity in New Jersey. All right, next thing. All right, so now we know that there's a cause of action. Maybe the plaintiff has filed that cause of action for us, so we're in good shape. And they've filed it within the statute of limitations, which is awesome. All right, how much money are we entitled to get back, right? Because this presentation is all about maximizing our reimbursement. So how do we know how much we're going to really get back? So the first question is, what is subject to a lien? And let's talk about it in New York first. Well, anything that we've paid in the workers' compensation case for medical or indemnity benefits. And the question sometimes comes up if it's a denied case. Yeah, even in a denied case, if you paid some medical, if you paid for some treatment, you paid for some lost time, even though you subsequently deny the case, all of that is recoverable. What you pay in a Section 32 settlement could be lienable. I can tell you that every Section 32 settlement that we do in this office, in our form language we put in, this is going to be considered a payment of compensation for the purposes of our Section 29 right to reimbursement. Attorney's fees could be lienable. Meaning attorney fees that we've paid in the workers' compensation case to the other side. Now, there's a lot more gray area about how about our defense medical expert, the cost that we pay for that expert, or our nurse case manager. Now, we will make an argument that those should be included in our lienable amounts in New York, but I can tell you there's also case law that says that maybe it should not, because the benefit of that IME or the benefit of that nurse case management or rehabilitative nurse, or sometimes called restorative nurse management, the benefit of that might really be to the carrier and not to the plaintiff or the claimant. And so for that reason, might not be. Things that are not lienable are going to be medical or lost time paid in lieu of first party payments. And that's a very specific thing that is defined very specifically in motor vehicle accident cases under Section 5105 of the insurance law. Now, what kind of recoveries and I'm going to talk about that in a bit, so don't worry about that. Other recoveries that are subject to a lien, or what kind of things, I'm really looking at bodily injury cases, personal injury cases. How about legal or medical malpractice cases that arise from the underlying workers' compensation action? So my workers' compensation injured worker goes to a doctor who harms them during the course of medical care. Certainly, we could make an argument that any money they receive from the medical malpractice that they were subjected to as part of the workers' compensation claim would be recoverable under Section 29 of the New York statute. So that's absolutely possible to do. Intentional wrong claims, claims that are arising under the motor vehicle insurance law, civil rights claims, but again, there's going to have to be a nexus there with the workers' compensation claims, and anything that is the substitute for or analog to a tort recovery, like a Military Claims Act or wrongful death claim. So what else is lienable? What's not subject to the lien? Okay. Voluntary settlements from employers' policies without wrongdoing or liability, right? So those could be some simple dismissal settlements that do not say, hey, I'm liable, or I am in any way saying that we caused this injury, right? Underinsured motorist and uninsured motorist claims. Why? Well, those are first-party claims, right? Those are claims in which typically the injured worker is insuring themselves against. And so we're not allowed to subrogate against our own employee, which would prevent claims against uninsured motorists or underinsured motorist policies held by the claimant. Okay. Now, if there's a contractual agreement between you and the employee that you are allowed to, then we can do it. Federal victim compensation law injury recoveries, things like the September 11th and Family Relief Act, would be excluded from a subrogation lien. And then legitimate recoveries for loss of consortium. So imagine a bodily injury case which settles for $1 million, and as part of that $1 million settlement, $50,000 is earmarked as a loss of consortium claim on behalf of the spouse. Yeah, we're going to see that's going to be excluded from any kind of reimbursement or recovery. But you got to be careful, and it's got to be legitimate. where it's $1 million settlement and $950,000 of the settlement is earmarked as recovery for loss of consortium, I think it's very clear that the plaintiff in that action is trying to sidestep our right to reimbursement and trying to be sneaky. And so we'll have to challenge those, and we have, right? And plaintiffs bar are very clever, and they will try to characterize as much as they can as a recovery for loss of consortium to avoid our reimbursement. Now, again, the recovery has to match the benefits that we've issued. And again, as I talked earlier about recovering on a malpractice claim, it's only malpractice as it relates to the underlying workers' compensation case. It's not any malpractice claim that they have against anyone. So we have to really make sure that there is a nexus between the recovery that we're seeking reimbursement from or subrogation against and the subject workers' compensation loss. All right, how about New Jersey? Let's talk about New Jersey specifically. What kind of benefits are lienable? Well, just like New York, it's going to be anything that we're paying for lost time or medical treatment, anything that's paid for permanent residual disability, even our share of attorney's fees that we have to pay to the petitioner on an order approving settlement. It's very typical in the state of New Jersey for the judge of compensation to award a 20% attorney's fee to the petitioner's attorney in a New Jersey workers' compensation action. And then the judge has discretion to allocate that 20% between the petitioner and the respondent. Typically, they allocated that 60% of the fee for petitioner's attorney will be paid for by the respondent, right? So it's an additional added on cost. And if so, in other words, if there's a $10,000 attorney fee awarded, it's typical that $6,000 of that would be attributed to payable by the respondent. Now, you've just paid someone's attorney's fees. You're entitled to recover that payment of attorney's fees in the workers' compensation case against the third-party tortfeasor. So that's something to keep in mind and not lose track of. And that also, by the way, would include the portion of expert fees that the judge orders. The judge can order up to $600 in fees per each expert and usually splits them so that the petitioner pays half their own fee and the respondent pays the other half. Which can add up in a case where 3 or 4 experts. So that is also lienable or something that you can recover from that third-party recovery. Of course, payments that are made in cases that are determined to be non-compensable, although they do recover at law elsewhere, those payments are absolutely recoverable. And Section 20 payments that you make can be reimbursed if you specifically reserve that. I just had a case where this happened, where we were paying Section 20 money because we knew we were going to be able to get some reimbursement under Section 40, and so we decided to make those payments, but we put it very specifically on the Section 20 order, which is a lump sum dismissal order, saying we reserve our rights to be reimbursed for this. What's not lienable? In New Jersey, IME fees, court costs, legal expenses, right, defense costs, all that stuff, not lienable. Funeral expenses, not lienable. Most Section 20 settlements are not lienable. And the reason they're not lienable typically is because a Section 20 settlement in New Jersey is not a payment of compensation under the statute. So it's this weird animal they've created so that we can do lump sum dismissals, but it's not supposed to be considered a payment of compensation and therefore would be normally exempt from a Section 40 reimbursement. And then the other things that are not lienable is New Jersey has what's called the amputation bonus, which if you have a full, complete amputation, you receive the 100% scheduled loss of use for that body part plus 30% more. So you get additional award of weeks. That additional amputation award is not lienable or not subrogable in New Jersey. So that's something to be mindful of. It can be quite large, $60,000, $70,000 in cases of significant amputations and cases where, for example, there's a high average weekly wage earner. New Jersey scheduled loss of use awards can be very large, and that's because you do not get a credit for any temporary disability paid in that jurisdiction. All right. What's not subject to a lien, or let's talk about recovery subject to a lien first. Recoveries from a tortfeasor or any functional source, just like New York, legal, medical claims, uninsured, underinsured motorist claims are subject to a lien in New Jersey. receivership claims, intentional wrong suits, and dependency benefits in wrongful death cases. Now, not subject to liens. Per quad claims, again, unless this is, just be thoughtful. These are often gamed and a lot of money is put into the per quad claim. You have to really look at those settlements as we just talked. Section 59 suits or Title 59 suits, those are claims against the state government in New Jersey. We're not allowed to recover that. And just like in New York, you have to make sure that the case that you're attempting to seek reimbursement from shares a factual nexus with the workers' compensation action that you've paid money into. All right, third pitfall. So now we've talked about what is the statute of limitations. We've talked about what is lienable versus not lienable. So how do you calculate that maximum lien? Third pitfall is going to be math and chicanery. Okay, I like the word chicanery. Now, the truth is most lawyers are not great at math, and determining the amount of a lien reimbursement does require the use of math. So, and by the way, it's a moving target often. If the workers' compensation case is still open, if it's still pending, then we can expect that that cost is changing while that third-party action is pending. So we want to make sure that we're getting the right amount. Also note, a settlement funding loan is not a cost or disbursement. It should never show up on a closing statement from plaintiff's attorney. We know now that in disclosure, particularly in New York, it is commonplace to ask about the presence of litigation funding loans, but it cannot be utilized by a claimant to increase their cost of litigation and therefore reduce our amount of reimbursement. Now, it's very common when we're talking about math and how we're going to get reimbursed for attorneys in New Jersey to say, hey, the max I have to pay that is not reimbursable is a third plus $750. That's what I'm going to take, right? 2/3 of it we know is subject to you, but that's not actually true. The statute says up to a maximum of a 1/3 deduction. And it's very true. If you look at the New Jersey court rules, they trigger settlements that are, attorney's fees that are less than a third. So in New Jersey, and I'm doing this from memory, but the court rule is that up to $500,000, the attorney gets a third. From $500,000 to like $750,000, it drops down to 30%. And by the time you get to $1 million, the attorney's fee is at like 25%. And so it's very possible that in a settlement for $1.5 million, the actual net attorney's fee is less than a third, which means that our reimbursement amount is actually higher. And that's something that we've got to keep track of because, the math on these things are very particular and very specific, and you don't want to lose out because of that. There are court rules which control, and that's the rule. I didn't realize it was my next pop-up in this slide. It's Rule 121-7 about the fees. Reminder again to look to actual closing statements. In New York, it's a requirement to file with the Office of Court Administration. But both states require the claimant to have knowledge and get a ledger showing exactly how much they received in their settlement, their third party or civil settlement. We need to see that. I don't take any attorney's word for it. I've been in this game going on 3 decades. I've had enough experience to realize I don't care what they tell me. I want to see it in writing, and I want to see the closing statement that you filed in court. Now, sometimes they won't provide it to us, and we can demand. We could say, look, because you're not telling me what the closing statement is, you're not showing it to me, you're saying it's not available, I'm going to demand a 70% reduction, an 80% reduction, or reimbursement. I'm going to demand something crazy because there's a reason you're not showing me your numbers. All right. New York addendum to math and chicanery is New York has a no-fault law, which contains a carve-out. And that carve-out says that we do not have a lien on any amounts paid in lieu of first-party benefits. Well, what does that mean? This definition of first-party benefits is very important. So the definition is that it is necessary medical treatment provided within the first year, indemnity up to $2,000 a month, right? So that's $24,000 a year, and reasonable and necessary expenses, that's usually car rental, up to $25 a day for the first year. So when you look at that, you say, well, okay, well, you don't have a lien on those things, but you realize that, and the extent or the limit on that is it only applies to cases involving the use or operation of a motor vehicle in the state of New York. So that can significantly reduce our ability to recover. If the first up to $50,000 in benefits paid out, again, as in accordance with the definition, that could be a pretty sizable carve out or reduction in our lien. But the thing I want you to note is look at the description there, the definition: indemnity up to $2,000 a month for not more than 3 years. So if the claimant's receiving $2,500, only $2,000 of that, it would be subject to our carve out. And that can make a sizable difference. And so when we're talking about math and chicanery and understanding how these different laws interact with each other, we've got to be very thoughtful about the way these benefits are paid. Oftentimes, the opposing party or the plaintiff come forward and go, look, it's a motor vehicle case. You guys have no lien. You should just waive it. You're not entitled to it. Or they'll say something like, you've only paid out $28,000, Greg, so you haven't reached your $50,000 threshold. That's simply not true. We have to educate the other side sometimes and say, no, the definition isn't $50,000 or less. The definition, if you look to it, says any indemnity paid over $2,000 per month actually is lienable. So that can mean that even in a case where you've paid out less than $50,000, you still have a right to recover. And that's because the portion of the claimant's recovery that exceeded that for that period of time comes back to you. Again, knowing the math, knowing the rules is very important. A better way of putting this is carrier does not have a lien on the amounts paid in lieu of first party benefits as defined in the insurance law section 5102. And again, that's where that time value of how much money are they getting paid per month, what are they actually receiving, what were the medical benefits receiving, all that stuff is going to be important for us in order to calculate our maximum reimbursement. Now, New York also has this great thing that says, hey, if your case is subject to that carve out because it involves a motor vehicle accident case, they have something called loss transfer, in which you can actually recover that $50,000 that was maybe withheld from you in your Section 29 reimbursement or Section 40 reimbursement by proceeding against the other carrier. And you could go to them and all that you have to do is show that there was a commercial vehicle, which is defined very specifically in the insurance law, involved in the accident. Now, the reason that's important to us is because we're workers' compensation employers or carriers. So very many times that our injured workers involved in an accident, they're driving a commercial vehicle, which qualifies for loss transfer. So even in cases where we haven't paid $50,000 and the money that was paid is really going to be carved out of our lien, because there's a commercial policy involved and a commercial vehicle involved, we're able to go and do what's called loss transfer litigation and recover that amount of money. It could be up to $50,000. It could be less. So just a useful thing to keep in mind. Fourth pitfall, negotiating tactics. We always recommend to our clients that we are pushing lien notices to opposing counsel. We're keeping them in the loop. I actually think it helps them settle their cases, that they are not confused or wondering how big the workers' compensation lien is. So what we do, particularly in New York and New Jersey, is we're serving lien notices at the inception of the case, as soon as we know there's a civil action, and then following up as the workers' compensation case is developing and before the civil action settles. We're holding the cards, right? At the end of the day, we are entitled to our reimbursement. Now, in New Jersey, you have to protect that entitlement by serving a lien notice. In New York, your lien recovery is automatic. It's self-executing. The burden is actually on the plaintiff in the civil action to make sure that the workers' compensation carrier is protected and recovers their maximum lien. So you're holding the cards in both of these jurisdictions. If you do issue that notice early and you keep the parties advised of what our demands for reimbursement are going to be, you're in the driver's seat. This is one of those situations where it should be relatively easy for you to collect. Now, a lot of times our adversaries will call me up and say, hey, Greg, I've been doing this. You know, they like to say stuff like, I've been doing it for 50 years. And, you know, we always whack this up. We do a third. And I'm kind of doing my old man voice because that's typically what these attorneys sound like to me when they call me up and say that. And I go, oh, that's cool. That's cute. That's nice that you've been dealing with these idiots that didn't know that the law doesn't say anything about a third, a third, a third. Now, that is a rule of thumb, right? And particularly in smaller settlements, I'll hear this a lot. Well, Greg, it's a $100,000 settlement. He's only going to get X. Can we do a third, a third, a third? Meaning you, the carrier, get a third of your reimbursement. I, the attorney, get paid, and my client gets, meaning the plaintiff, gets a third of whatever the net recovery is. And you go, okay, that sounds cute and nice, and it does sound fair on some weird level, but it's absolutely unnecessary. And there is no rule of law or case law that says you ever have to accept that. So if you're doing that, my advice is always no. And when they're asking you to do this, when they're asking you to reduce your recovery amount or your reimbursement amount, they're always going to say the same stuff to you, and it's always lies, right? First thing to say, my case stinks. I got bad liability. If I go to trial, I'm going to lose, Greg. Or they'll say, my client, his uncle got $1 million for this accident, and he's never going to accept this. You've got to waive your lien. Or they'll say things like, if you're not agreeing to a third, a third, a third, you're being a jerk. And you know what? I've been before Judge X 15 times, and Judge X hates greedy insurance companies. And if I tell Judge X that you're blowing up the settlement because you won't accept a third, you're going to be the bad guy, and Judge X is going to get you. Well, those are all lies, right? The judge has absolutely no authority to craft or change the terms of a settlement or cram down our reimbursement based on whatever is going on in their civil action. They literally have no authority. The statute does not grant them that authority. How about when the claimant comes up to you and says, oh, my case is so bad, it's garbage, I'm thinking about just walking away, we're going to lose on summary judgment anyway, I'm just going to dismiss this thing. If you don't do a third, a third, a third, or reduce your lien to nothing, I got to walk away from this thing. You go, okay, walk away. You've done all the work. Thank you very much, by the way, for doing all the work. And I will just come in and step into your shoes and subrogate the action and take whatever settlement you didn't want. Fine with me, right? That's kind of ridiculous. Or they'll talk about they have a timed settlement offer. Greg, if you don't agree to this reduction of your lien by midnight tonight, it's off the table. And I'm like, well, I don't really respond to threats because the statute's in my favor. The statute says I get reimbursed no matter what. If you take something, I take something. So I don't feel time threats. Or this is going to cost you more than it's going to cost me. It's going to take you more time to recover this, and it's going to take me. I'm like, no, the work's been done. I don't have a challenge with picking these things up and walk them across the finish line. Don't fall for it. I really don't even negotiate with them. Once they start making those kinds of threats, I'm going to abandon my case. I'm going to lose on summary judgment. I'm like, oh, good luck. I hope that works out for you, but I'm not waiving my lien at this moment. I'll wait until you get that summary judgment, and then we'll talk, right? So those are those things that are, just a warning to you. Typical negotiation tactics that you have to be ready to overcome or respond to. All right, fifth pitfall we're going to talk about is not being in the room. Not being in the room, and we think it's valuable. First, you can do a formal intervener. You can step into these cases. If you've got $1 million lien, it might be worth it to do that so that you're a part of the ongoing process, and you're just getting a seat at the table, right? You're going to be a non-party. You're not going to be part of the disclosures. But when it comes to settlement, when it comes to those compliance conferences or settlement conferences, you're sitting there at the table and you're ready to make sure that you get your recovery. Intervening basically copies you in on the case, and you can sort of watch it progress. And you could, as these milestones are unfolding, you're getting to see how much reimbursement you're going to obtain. Even if you have not intervened, but the parties agree to private mediation, you can ask to attend or be available. So I do that a lot. I'll say, look, I'm not going to go to your mediation, but here's my cell phone number. And if you guys get close to a number and you need someone to talk to, you can reach out to me and we can start talking about this reimbursement right that my client has. And so I feel like that's an important thing to do. My partner, Tashia, does it all the time for her clients, she's just available. And I also think it's important because sometimes in those mediations, when the mediator is going between the rooms, who's there to answer for, hey, why is the workers' compensation lien what it is? And how much of that lien is recoverable? And maybe, can some of it be waived in the furtherance of an overall settlement? So my advice is being there at that mediation. And we're talking about cases where that lien value is maybe over $500,000. It's worth it to spend that time and effort to make sure that you get your maximum recovery. A very valuable use of time. Last thing we're going to talk about is feeling constrained or stuck by the law. Don't feel like, even though the law guarantees us our maximum reimbursement, it tells us what we're going to get. We've got a lot of leeway to negotiate other things or stipulate other things. Third-party consent settlements or agreements in New York is just a contract, right? It's just a settlement contract. It's just basically a rider on top of their settlement contract that says, if you do this, I get that, right? That's all we're saying in a consent agreement. You look at those things, and mine are like 6 pages long because they're very boilerplate full and verbose, and we're really trying to protect us against anything that could come out of the blue or the woodwork. But the truth is, even a simple consent letter, because I've gone back and forth in negotiations where it starts off at 6 pages and ends up at 2 pages. Even a simple settlement consent letter that guarantees our reimbursement rights and defines it is going to be functional because the statute and the case law in this area are so clear. There's very little gray area that we have to really work about. The biggest questions that we have, or the biggest challenges we actually have in determining our reimbursement sometimes, is which law applies. Is it and putting together insurance law 5102 and 5105, putting together loss transfer rules, putting together what are the rules in the various jurisdiction, and then which jurisdictions workers' compensation recovery statute, section 40 or section 29, applies, right? So all those things are what comes into our determining how to get our best recovery. We love to try to get creative. We love to try to settle or resolve the entire case through our waiver or reimbursement agreement in the civil action. Another thing that we can do is try to shift money around to ensure that attorney fees are not getting blown up in the civil action, or that they're avoiding contribution back to the workers' compensation carrier by, for example, saying the entire awards for loss of consortium. I've seen those things too. Sometimes we are also thinking about, hey, can we give something up now that's going to help us close our workers' compensation long tail liability into the future? The last thing I'll talk about is freezing the lien. Sometimes you want to say, here's what the lien is, and it's done, it's closed, and that's because we have a closed period of indemnity or a closed period of compensation in the workers' compensation action. And sometimes you want it to be ongoing and open, right? And you want to say, here's what the lien is as of this day, and the day you sign this agreement, that's frozen, and then everything going forward is going to be paid at this specific rate, usually the cost of litigation in New York, or in New Jersey, it's usually a third. All right, so very simple, very straightforward way of resolving these. And of course, the last thing we're going to say is, if we can resolve cases on a global basis, we love to do that. Meaning, by waiving my right to recovery in New York or New Jersey's under their statute in the civil action, I'm able to close my workers' comp action, and we have to consider that as a viable option. Remember that you're in the driver's seat. Your right to reimbursement actually supersedes the claimant's right to the recovery on their own award. So just because they went through a 9-day jury trial and got $5 million and did all that work doesn't mean they get the money first. We're actually entitled to reimbursement before they can disperse those checks to their own claimant or plaintiff. In New Jersey, my advice is always to issue a Section 40 notice early. And as soon as you can. So our practice here is, as soon as a case is referred, as soon as a claim petition is filed, we issue our Section 40 notice. We do it at intake. That gives you powerful leverage. You're now really in control of these cases. Once you've put the parties on notice, they have the obligation and responsibility to come to you with offers. You always have reimbursement, subrogation, and credit offset rights unless you waive them, and that's powerful. If they don't want to agree with you, or if you don't want to agree with them, their only option is to seek judicial approval of the settlement. They can't, for example, force you to compromise or reduce your lien. There's no case law or statutory authority for any judge to do that. So when they come to you and say, I want a third, a third, a third, you said, nope, we want our recovery. Let's say it's 66%. I want all that money back. And they say, oh, we're going to fight you. I'm not paying you that. That's not fair. I'm going to file a nunc-pro-tunc motion. I'm going to go for a judge. I'm going to say, judge, approve the settlement subject to this reimbursement. The judge has no authority to quash or reduce or cram down your reimbursement right in any of these jurisdictions. So that's very important. They want their money too. Practically speaking, I've never seen a claimant or third-party counsel walk away from a settlement because they were unhappy with how much they had to reimburse us. Yeah, they don't like me. They're not inviting me to their golf outings, maybe, but who cares, right? At the end of the day, my duty is to my client, not to opposing counsel. All right, let's move over to questions. I'm hoping there are some great questions today. This is a very fertile topic, and we've got a good-sized group here today. So let's take a look at what we have for questions. Okay, so Genevieve asked the question, Greg, can the workers' compensation benefits be suspended if no consent is received from the comp carrier? Yes. So in a workers' compensation context, and this is in New York only, right? New Jersey does not require consent to settlement. Only New York does. So it gives us that power. In New York, an insurance carrier or the self-insured employer has to consent to a civil action settlement. And if they do not, the claimant has the opportunity to go and file a motion before the judge that their case is pending before and say, Judge, here's why this settlement is fair and just, and you should approve it, of course, subject to their reimbursement rights. But where the claimant goes and just takes a third-party settlement without seeking our consent, we can immediately stop paying in the workers' compensation case because that violates Section 29 and means that our liability in the workers' compensation case is stopped or suspended until that consent issue is resolved. So that's the power. They could be forfeiting all of their workers' compensation rights and giving up their rights and maybe future money by taking a settlement in a civil action that they didn't get your express approval for. So great question, Genevieve. Thanks for asking it. All right, I don't see any other questions. I've been talking for about 40 minutes. I thought this would generate some more questions on this topic, but thanks for joining me here today. I hope you learned something. I hope this was useful. If you do have a question and maybe you just didn't type it in fast enough and I didn't respond quick enough, that's fine. Please be comfortable just sending me an email after this with your question. I love talking about this stuff. All right, everybody. Thank you so much. Thanks for coming today, and I'll see you next month.